Welcome to our session regarding Chapter 3, Constitution, Statutes, Administrative Law, and Court Rules, Research and Analysis. Again, this is a presentation on Chapter 3. We still have a little bit of information to cover on Chapter 2. I think we'll just wait till we get together live again. Thank you for your understanding. As I explained, this is a bit of an emergency situation. So again, I'm going ahead and recording this video. So again, let's go with Chapter 3, and I'm going to go ahead and share my screen. Again, Chapter 3, Constitutions, Statutes, Administrative Law, and Court Rules, Research and Analysis. So we've talked about this before, sources of law, and we're talking about sources of law other than case law. So now we're talking about constitutions, statutes and ordinances, regulations, and administrative law. Now, as we've mentioned before, there is a hierarchy of enacted law, and right at the top is the US Constitution. That is over everything. And you can see there that hierarchy going down, clear down to local agency rules. So what does that mean? I have a couple of quotes here. When a state law is in direct conflict with federal law, the federal law prevails. A state law can afford more rights to its citizens than federal law, but is not meant to reduce or restrict the rights of a US citizen. So we're going to see that in a little bit. We're going to talk about state law conflicting with, or really, I should say, local law conflicting with with state law, I should say. And so I think the first question you have to ask is really, is there a conflict? So here, when this quote is talking about when there is a direct conflict, okay? When there's a direct conflict, then federal law is going to prevail. Or if there's a direct conflict between state law and local law, state law is going to prevail. And again, a state law can afford more rights, but it can't infringe on the rights that are granted to a US citizen by federal law. And then as a general rule, a hierarchy exists such that a constitution or charter, law or rule may not contradict a higher constitution, law or rule. That makes sense, right? Again, this sort of general hierarchy. So now you're going to remember this golf example we had. We're going to keep coming back to this example today. And you can see with the red print there, or font, I've made some changes to our golf scenario. Remember, Tom owned a brick and stucco house. I think we've established that's not really important, but it is important that he owned it on the fairway of Duck Haven Golf Course in Bowling. Now, I've made it Bowling Green, Ohio. We're going to see why that's important in a little bit. And so while he's out having fun with friends, he gets hit with an errant tee shot hit by Bob Hacker. And, you know, Tom suffers a broken nose, suffers some medical expenses, and wants to go after the golf course for just negligence, design defect, whatever he can come up with to try to recover not only his medical expenses, but pain and suffering. So you're familiar with that scenario. We've been talking about it. Well, you can notice down there sort of midway through this section, I've included a scenario whereby Tom is now maybe in trouble for something that he did. So let's look at this. The time Tom was hit by Bob's golf ball, not only were his retired friends enjoying the evening with him, but so was his pet coyote, Wiley. When Tom screamed in pain, Wiley became agitated, jumped the 5-foot fence surrounding Tom's property, and proceeded to attack and kill 3 of his neighbors' pet peacocks. So Tom wants to get reimbursement for his medical expenses, but he's also, going down to the bottom, he is also concerned that he may get in trouble for keeping a pet coyote. So he also wants to know if he's subject to any type of punishment not for monetary damages to the owner of the peacocks. He's already settled with them. But he wants to know if he can get into any type of trouble or punishment for keeping Wiley, a coyote. So when we're thinking about this coyote part of the scenario, boy, how do we even begin? And that's sort of what this chapter is talking about. Where do you start? And we've talked about crafting an issue. So I really think it's important to, again, to go back and remember what are our key facts, use those key facts to craft our issue, and then use our issue, really hone that down to figure out what in the world we should be researching. So really, one way to look at the issue is keeping a coyote a violation of law, okay? Now, when you think about, well, is that federal law? Is that federal statutory law? Is that constitutional law? Probably not. Maybe a federal law could come into play here. But remember, we're in the state of Ohio. Let's assume that the peacocks were in Ohio. They were his neighbors, I believe. So, Tom's in Ohio, the golf course is in Ohio. So we might want to start with state law. I think my point here is that in every research project, you don't need to uh, necessarily start at the top. You don't need to start with, well, what does the US Constitution say of this? It's a little bit messy in how to start your research. But in this instance, I would start with Ohio law. So let's start and see if Ohio law has anything to say about this. Yeah, there's our friend Wiley. So the anatomy of a statute. So we're going to talk about Ohio statutes here. So let's go to our legal resource guide here. And you can see this should be familiar with, since we had that discussion with Melly, so I think you should be familiar with this, and we're revisiting this again now. So right now, let's go over to the home page. And again, this should look familiar. But you can see at the top, since we want to go to statutory law or enacted law, we'll go over here to federal and state codes. We'll click on that, see our Ohio flag there, and there's the Ohio Revised Code. Now, the Ohio Revised Code is what the listing of Ohio statutes is called. So let's click on that and take a look at the Ohio Revised Code. And so you can see the Ohio Revised Code is divided up into or organized by titles. So there's Title I, Title III, all the way down to, so they don't necessarily go in orders. There's some numbers that are skipped there. And you go all the way down to Title 63. So now I'm a little bit ahead of you here because I've already researched this issue. So not going to take a lot of time to figure this out, but let's go to, well, first of all, let me show you something else here. This is Title 13. This doesn't have anything to do with coyotes, but I want to show you this because the book talks about short titles. And so this is Title 13, and it deals with commercial transactions. And Ohio has adopted, if not all of the Uniform Commercial Code, most of it. And here is the general provisions. So again, you can see short titles. And so the short title here is these sections or chapters of the revised code may be cited as the Uniform Commercial Code. So there's a general Uniform Commercial Code out there, all right, separate from Ohio. Okay, it's not necessarily the law unless it's adopted by a state, and Ohio has adopted Uniform Commercial Code. And forgive me, I believe, again, they've adopted the entire thing, but there may be some little bits and pieces that they haven't. That's not really important for our discussion today. But what I'm trying to say here is that the Uniform Commercial Code is the short title for these sections. Now, not every statute has a short title, but for whatever reason, Ohio decided to give these chapters the short title, of the Uniform Commercial Code. So if somebody says in Ohio, look, I have an issue regarding sales of goods, let's look at the Uniform Commercial Code in Ohio, well, you know where to go. All right, let's go back. You can see down here, again, organized by, go back to titles, we open up titles, and it's organized by chapters. Now, we're going to be dealing with Title IX, so let's just open Title IX, and you can see it's divided into various chapters. Now, I'll say this is a very inefficient way to research something. If I was starting off this way, probably not the best way to research about the issue regarding whether I can keep a coyote as a pet, because I'm going to have to go through all of these types of things here. I'm going to say, well, maybe it's a municipal corporation because I'm in a municipal corporation, or maybe it's, could it be conservation of natural resources? I don't know. So again, not real efficient, but I do know that we will be dealing with Title IX. And so you go down to the chapters, and here again, it's difficult. Are we dealing with bakeries? Probably not. Meat inspection? No. So all sorts of different things here. And we get down to possessions of wild animals and snakes. And this is the chapter we want. Now, before we dive into this section, so the titles divided into chapters, chapters divided into sections, let's go back and let's take a look at another form of the Ohio Revised Code. And we've talked about this before. It's this pages Ohio Revised Code annotated. So this is the revised code, just what we've looked at, but this is put out by this entity called Pages, and it's annotated, and we're going to see what that means in a minute. So let's go there. And you can see, okay, here are our titles. Okay, there's that commercial transactions again, but we're going to go up to Title IX, agriculture, animals, fences. We're going to click on this little button here, and we're going to look for our chapter that we want. You see, there's a lot of different chapters here. Oh, here it is. Possession of dangerous wild animals and restricted snakes. So we're going to click on that. I'm going to come back to that definition section, but here is possession of dangerous wild animals. And again, we've looked at this before, so this should look familiar to you. And here is our section, okay? Possession of dangerous wild animals. And it's pretty clear here. And there's a bunch of some exceptions that really don't apply in our situation. But if you're researching this, you would need to go through each of these, okay? You need to read the entire statute. But A, no person shall possess a dangerous wild animal on or after January 1st, 2014. Now let's assume that we're in the year, with our scenario, we're in the year 2025. So clearly we're past this deadline, if you will. Now, so when we look at this, you automatically should think, what is a dangerous wild animal? So we're going to go back, because remember, we saw definitions. We're going to see if dangerous wild animal was defined in Ohio. And we go down here, oh, there's circus, but here it is, a dangerous wild animal, okay? Now, this language is really important, and we'll probably come back to this later, but you can see here, dangerous wild animal, that's our phrase, means any of the following, including hybrids, unless otherwise specified. And then there is a list. Hyenas, gray wolves, I won't read through all of them. You can take a minute or two or second or two to take a look at this. Mountain lions, cougars, can't keep those. Can't keep a pet rhinoceros. Even at Christmas time, you can't keep hippopotamuses. So here's a whole bunch of things that Ohio law indicates that you cannot keep. And so they have this list, okay? Then they have dangerous wild animal, does not include a domesticated animal that is considered livestock as defined in. And I bet we can safely assume that our coyote is not livestock. So we have this list. And the interesting thing about this list, if you looked at it really closely, you wouldn't see the word coyote. Wow, you see a lot of things that are like coyotes. You see gray wolves, excluding hybrids of gray wolves, but I don't think a coyote is a hybrid of a gray wolf. There's lynxes. So there's all sorts of things here, but no coyotes. So let's go up here. So again, this is our citation here. This is our definitions. We're going to go down. We're going to see why this is annotated. So we're going down through the whole text of this statute. Nothing different about this statute here than is in that Ohio Revised Code section that we looked at before. Okay, this is just giving you some useful information here. We'll go down. Okay, history. Okay, so here's the history of this statute. Looks like it was effective September 5th, 2012. Now some annotations. Now this really starts to help you in your research, okay? There's some editor's notes. Oh, and they've included some decisions. Not all of this. You're probably better off looking at case law under Lexis Uni, but here are some decisions. And so this is kind of helpful to get started. And so we're going down here, we're looking, and I want to go to one that, ooh, wow, this really looks important. Dangerous wild animals. And so this little synopsis of this case says, the trial court properly found that bobcats, not coyotes, but bobcats were not included in the list of dangerous wild animals that could not be licensed under Revised Code Section 1533.71. The list included common names for a species other than a genus. So lynxes, as included in the list, did not cover bobcats. Okay, so if we really looked and thought about that, here's a case that's concerning bobcats. And they found that bobcats was not included in this list of species that were considered dangerous wild animals. Wow, we're not dealing with bobcats, we're dealing with coyotes, but bobcats weren't on that list. Coyotes aren't on that list. We should look at this case. So let's click on, and this is so easy now with the way the internet works and the way these databases work, just to click on this case and take a look at it. So we're going to click on that case and go to that case. Now, so here is our case. Now, the first thing we want to notice here is that, oh, there's our shepherds. Remember we talked about that? This is going to tell us if our case is still good law. So we can see here, no negative subsequent appellate history. So this is a Court of Appeals 10th Appellate District case, okay, down in Franklin County, Ohio. And so we can see here that there's been no negative subsequent appellate history. In other words, Supreme Court of Ohio has not overruled this case. And there's a couple of decisions that cite this case, okay? So safe to look at this case. Let me go to my notes on this case here. First thing I want you to look at here is, gets a little confusing. So here is an individual by the name of Adam Federer. Sorry, just trying to get my notes together here. Okay. So, Adam Federer. Now, the interesting thing is, he is called the appellant-appellee. Wow. Both sort of two equal terms. So a lot of times we see plaintiff and appellant, or plaintiff and appellee, or defendant and appellee. But here we have appellant and appellee, or appellee, and we also have appellee / or dash appellant, okay? Which is a little bit awkward. So that should tell you a little bit about something that's going on. So it means that Adam Federer probably lost at some point, And Adam Federer probably won at some point. And the same thing with the Ohio Department of Natural Resources. Let's go down here. Let's get through some of this, some core terms. There's a case summary. We can sort of skip all that. We really want to get down to the opinion. Okay. So here is the opinion itself, the decision. And so you can see here the Ohio Department of Natural Resources, ODNR, appellant, appeals. Okay. They're appealing from a judgment of the Franklin County Court of Common Pleas. Okay. That court, that Common Pleas court, reversed ODNR's decision finding a bobcat is a dangerous wild animal pursuant to, and there's our statute that concerned all those definitions. So ODNR lost the Franklin County Court of Appeals level. Okay. The court reversed their ODNR's decision finding a bobcat is a dangerous wild animal. Adam Federer, appellee, has owned a bobcat since 2003. Okay. Since 2003, ODNR has issued non-commercial propagating licenses to Federer for his bobcat. Okay. Now, so he owns a bobcat. He owns a bobcat for a long time. And the Ohio Department of Natural Resources, Division of Wildlife, has been giving him licenses for his bobcat. However, September 2012, the Ohio legislature comes in. Okay. They enacted the Dangerous Wild Animals and Snake Act to regulate the possession of dangerous wild animals. As defined, there's our statute again. So state law comes in and says, no, 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 no. We're going to regulate as a state law. You can't keep dangerous wild animals. We're going to define what those are. The act is administered by the Ohio Department of Agriculture. So pursuant to another section we're not going to look at, ODNR cannot issue a license for an animal that is defined as a dangerous wild animal under that definition. Okay, now we know bobcat's not in there. So March of 2014, appellee applied to ODNR for a license. Now that is Federer. Okay, so it gets confusing. So sometimes when you're reading a case, maybe you need to print it. This is what I might do sometimes. You need to print it and write the person's name there so you can just keep it straight. Because this appellant, appellee going back and forth, plaintiff, defendant, it can really get confusing. Okay, so here the appellee is Federer. So it's giving some history here. Back in 2014, the appellee applied to ODNR for a license for his bobcat. On March 25th, ODNR denied that license application. Federer then appealed that decision. A hearing officer in July issued a report and recommendation upholding the denial of the license. Now, why did he do that? The hearing officer found that because a bobcat is considered a species of the lynx genus, and lynxes, I hope I'm pronouncing that right, not a biologist or an animal type person, but it says, and lynxes are defined as dangerous wild animals under that section. So lynxes was there, but not bobcats. And the hearing officer saying, well, bobcats fits under that category of lynx. So consequently, you can't own a bobcat either. You can't get a license for a bobcat. Okay. So did not issue the license. On August 2014, ODNR issued a final adjudication order adopting the hearing of the hearing officer. So that order gets appealed, and that gets appealed to the Franklin County Common Pleas Court. Federer does that. And on January 15th, the court issued an opinion and judgment entry reversing ODNR's order. And here's what the court found. The court found that that section that we looked at, definitions, used common names for animals, and it specifically omitted bobcats. So what that lower court said, or the Franklin County Court of Common Pleas said, look, the statute is using common names, it's not using these scientific names, okay? And because they use common names and they didn't use the word bobcats, bobcats not included. The court further found, reading here now, the court further found that the use of the term lynxes in that section was not meant to include the entire lynx genus. So now ODNR appeals the judgment of the Common Pleas Court and asserts several assignments of error. Now, there's a bunch of history that goes on here, talks about just some stuff that, yes, is important, but not really important for our purposes today. Want to go down to T9. Down there's our statute. They're including the statute in the case here. So they're quoting the statute. There's all our animal names. So now we get to the crux. So a lot of times a court opinion is going to go through some history of what happened. We just went through that. It's going to go through some procedural history. But now we get to where really the crux of the decision. So accordingly, the issue before us is whether the term lynxes, okay, under that definition of lynx, includes bobcats, okay? So how do they reason this out? Well, first they say, we first note that ODNR initially argues that bobcats are included within the term lynxes because a bobcat is in the scientific and technical meaning of the term lynxes. Okay, now what is ODNR doing? They're pointing to the testimony of an expert. And this expert says, gets us some pretty intricate types of things here. But it says, but Dr. Melissa Zimmerman defines bobcats as a species of lynx, and that a bobcat's genetic and physical characteristics make it a species of lynx. The court goes on to say, however, appellee does not contest that bobcats are a species of lynx, and we do not find the fact particularly useful. So the court's saying, yeah, great to know. We don't really care about that, okay? We don't care about the scientific technical meaning of the word lynx. B10, to answer the question of what the General Assembly meant. Now, so let's take a time out and talk about this. So this is where we are going to talk about these different way to interpret statutes a little bit later on. But here, what you need to kind of think about is if something is not clear in its face, then you need to try to figure out, well, what did you may, if it's not clear, you need to try to figure out what did the lawmakers mean when they put this law on paper, when they adopted this law, when this law was passed, okay? So to answer that, so the court here says, to answer the question of what the General Assembly meant by lynxes, we, like the trial court, find the best course is to consider the language and overall scheme of our section. The trial court found that the legislature used common names. So say, here's what the trial court did. They believe that the legislature used specific common names, not scientific names, for different species of animals to define whether they were dangerous wild animals and purposely admitted bobcats. Okay, so it's talking about here what the trial court did. And the trial court found that the term lynxes could not be broadly interpreted to be the entire genus or everything that falls under the scientific name lynxes. And the court here says, we agree. They say the statute uses the common names of the animal species in the provision. Nowhere in this section did the legislature identify an animal using its scientific genus. So they're looking at the context. They're looking at other words. And they say that nowhere did the legislature identify an animal using its scientific genus. They were using common names. The term bobcat is the common name for a species within the lynx genus and is not specifically included in the provision. The legislature used everyday language and terms to describe the animals included in the definitional section and did not employ scientific or overly technical language. Okay, let's go down a little further. I go on to say lynxes refer to the common name for a species instead of a genus is supported by the statute, which provides that. And we won't go through that. Just again, it's sort of bolstering its decision here. Go down to P13. Looking for a specific section here. Talking about the Ohio Administrative Code. Apparently ODNR argued that about polar bears. They said ODNR's argument regarding the polar bears actually supports the trial court's interpretation of lynxes. ODNR claims the term polar bears is also not included, yet there's no dispute that ODA may include polar bears in its rules as being a dangerous wild animal because that species included is under the broad name of bears. So let's go down. Here, the Common Pleas Court's reading is consistent with the testimony of Scott Zody, the chief of the Division of Wildlife at ODNR. Zody testified that he was the chair of a task force that submitted to the legislature recommendations for ways to regulate certain dangerous and wild animals. So you see what's happening here is that now they're looking at testimony from this chief of the Division of Wildlife. He was the chair of the task force so really they're sort of looking at the history of this law. What were the deliberations that went into deciding whether to include the word bobcats or whether to include the scientific name of lynxes and make sure that the scientific name lynxes included these other animals? So the court is doing here is, wow, we don't see bobcats. We think these are common names, and now they're bolstering that decision by looking at the testimony of individuals who were involved with creating this law. Okay, and there, if we read through that, we would see that bobcats. That this just certainly continues to bolster the opinion of Federer. There's a certain section here I want to get to in P15. Let me find it here. Oh, this is good. So Zody also noted, now we're talking about bobcats. Zody also noted that the task force recommended to the legislature that coyotes also be left out of the definition of dangerous wild animals, and legislature likewise did not include coyotes in 935.01. Let me read that again. Zody also noted that the task force recommended to the legislature that coyotes also be left out of the definition of dangerous wild animals, and the legislature likewise did not include coyotes in the definitional section. Wow. Bells should be going off in our head when we find that case, okay? Not only is it talking about the same issue, bobcats, common names, not included, but it also mentions coyotes. We go down to P17. For the foregoing reasons, we find that the trial court did not err when it found that bobcats were not included in the list of dangerous wild animals, and that the denial of Kelly's application was not in accordance with law. Therefore, ODNR's first assignment of error is overruled. And that's the main thing that we're concerned about here. So to see what we're getting at, I'm trying to show you here that we have a list in a statute, okay? Our item is not on that list. And we kind of wonder, why isn't it on that list? Why are wolves there, but coyotes aren't there? Is it really in the list? And we see a court decision here saying, no, coyotes, like bobcats, really aren't on that list either because we're using common names of animals. Bobcat's a common name, coyotes a common name. Now, so I hope that was helpful as we talk about legislative law. Let's drill down a little further. I want to take you somewhere else. Let's go back. So we're going to go back and back out of this. Oh, we're going to go to the Bowling Green city ordinances. Remember that change I made? I said that where Tom was living was in Bowling Green. So he had his coyote in Bowling Green. So being good legal researchers, we think to ourselves, maybe we need to take a look at the local ordinances and see what's going on. So let's go to the Bowling Green city ordinances. And again, a lot to go through here. Take forever to go through each one of these, but it's nice we have a search function. And if I go to the search function and I type in the word coyote, and let's search and see what happens. Oh, we have a section that says prohibited animals specified. And here we go up and we see it shall be unlawful for any person to keep, maintain, or have in his or her possession or under his or her control within the city any poisonous reptile or any other dangerous or carnivorous wild animal or reptile, and vicious or dangerous domesticated animal, or any other animal or reptile of wild, vicious, or dangerous propensities. So in Bowling Green, kind of have a similar ordinance to the statute that we just looked at. And they're saying, hey, in Bowling Green, you can't have these animals. What is a dangerous animal? We're going to go through here. Boy, here is a long list. And just like the other list that we saw in the Ohio Revised Code, here's a list of animals, but lo and behold, there is our friend the coyote. Okay, so Bowling Green says you can't have a coyote. Okay, so unlawful for any person to keep or maintain a coyote. Go back to what we were looking at before, the Ohio Revised Code. Let's go down to we were looking at before. Let me try to find that for us here. There we go. Title 9. Protection of wild animals. And this is saying no person shall possess a dangerous wild animal. Wow. What do we do? Bowling Green ordinance conflicts with Ohio law. So let's get out of this and go back to, if I can do that, go back to our PowerPoint. Hopefully you're seeing that there, and I'm going to go to the next. So here's something I pulled up. So what happens when state and local laws conflict? And here's the citation under this. Under this, a state preemption doctrine, the state government can nullify a local law that conflicts with, or in some instances simply deviates from, state law. Often these cases revolve around the power to give local governments either through the state constitution or through to give power, revolve on the power given to local governments either through the state constitution or through state legislation. So just wanted to bring this up, an interesting conflict, or is it a conflict? Here, the state of Ohio is saying you can't own these animals. And here, also, the city of Bowling Green saying you can't own, yes, wild dangerous animals, and one of those is the coyote. And Ohio is saying, no, not a coyote. So Ohio leaves it out. Bowling Green leaves it in. So the first question I think we should ask is it a conflict? Um, is there a direct conflict that the state law would control the local law? Um, I'm not really sure what the answer is, and maybe that's something would have to be litigated. So our person, Tom, might fight uh, the city authorities if they came after his coyote and say, "Hey, look, state law doesn't." I don't know how that case would turn out, but this sort of goes with that hierarchy. And again, the issues can be complicated and maybe sometimes need to be litigated. So look forward to your questions about that maybe when we get together again. The book talks about court rules. Let's just quickly look at that court rules. So if I just go to my own third district court of appeals where I was a clerk, you can see here that the third district court of appeals has its local rules, just how they want things done. Okay. So there are the court rules, and I'm assuming all the districts have these similar court rules. With me here? I hope I have the right one up here. So, yep, there we are. We're almost done here, but just a couple of considerations here. The plain meaning rule, considerations of how to interpret statutes. So, and again, this is in your textbook. Plain meaning rule, when required to interpret a statute, a court will first look to the plain meaning of the language of the statute. Sort of what we were just looking at, really. A little variation of that, but I think to a certain extent, the court was saying, look, a bobcat's a bobcat's a bobcat. It didn't say bobcat, so a bobcat's not included. What's the plain meaning? Okay, legislative history. So sort of some of that involved with the case we're looking at. The record of the legislation during the enactment process before it became a law consists of committee reports, transcripts of hearings, statement of legislatures concerning legislation, and any other material published for legislative use regarding the legislation. Trying to get to the meaning of something that's maybe not plain. Okay, so you're going to look at legislative history. We're starting to get into some Latin phrases. So if you go to law school, you're going to be getting into a lot of Latin. This, I won't try to, although I did have 2 years of Latin in high school. I'm not sure I can pronounce this. Let me give it a try. Expressio unius, the expression of one excludes all others. So if a statute governing artists lists potters, glassblowers, painters, poets, writers, sculptors, does not include weavers, weavers are not covered by the statute. So again, you need to be careful, however. Sometimes they're going to say, hey, governing artists include, but is not limited to the following. Okay, so that's favorite language of attorneys, including but not limited to. So be careful of language like that. Okay, but if there's an express list with a period at the end, let's say, then the expression of one excludes all others. They really meant what they said. It's that list. And we see that operating with that definitional section we looked at with regard to dangerous wild animals. It was that list. Okay. I won't pronounce this one. Of the same genus or class. It's sort of that expression, I think, genus in that decision. Here, and this is from the book, a statute regulating self-propelled vehicles. This is an example. Statute regulating self-propelled vehicles lists, quote, bicycles, tricycles, unicycles, and other devices. Could that be tractors, cars? Well, here, other devices is limited to mean devices of the same class or kind as bicycles, your tricycles, and unicycles, okay? Motorized vehicles are not other devices within the meaning of the statute. Pari materia on the same subject matter. Again, here's an example. The state's Fair Housing Act prohibits discrimination against an individual on the basis of gender preference. The state's Fair Employment Act also uses the term gender preference. The term should be interpreted consistently in both statutes unless each statute has a definitions section that gives a clearly different meaning. So, talking about this phrase gender preference, States Employment Act uses that term, gender preference. The term should be interpreted consistently in both statutes unless there's a definition section that gives it a different meaning. Okay. The last antecedent rule. Qualifying words and phrases apply to the words or phrase immediately preceding and do not extend to other more remote words or phrases. So here from the book, a DWI statute provides that driver means every person who drives or is in actual physical control of a motor vehicle upon a highway. The phrase upon a highway modifies the term motor vehicle. It does not modify the term drives. Intended remedy. Interpreted in a manner that furthers the intended legislative remedy. Entire context. Words, phrases, and subsections are to be interpreted in the context of the entire statute. Okay, so again, that's just a general rule of interpretation. What is the context? Okay. Constitutionality. Statutes are assumed to be constitutional and should be construed in a manner that preserves their constitutionality if possible. And finally, criminal statutes are to be interpreted narrowly. Okay, so that includes our session. Thanks for listening, watching. I know this was a little different, but I'm going to close us out now, and I will see you again on hopefully Thursday. Thanks, everyone.